The European Parliament has passed the EU AI Act. Here's what that means and why it probably feels like you've heard that headline about 6 times at this point. Welcome back to the AI Breakdown. The breaking news this morning is that the European Parliament has passed the AI Act. I couldn't help but laugh when I saw a meme from Keir Lamont on Twitter who wrote, "How the EU AI Act news sounds to us non-EU legislative process understanders," with an image that says, "Rest assured, this will be the 6th time we have passed the EU AI Act, and we have become exceedingly efficient at it." The joke here is, of course, that it is a very complex process to get legislation into law in the European Union, but this was in fact a significant and important step. Back in December, the European Union had gotten to provisional political consensus, which was itself not the first time that they had voted on this set of rules, but in Wednesday's session, the European Parliament actually endorsed the full act. The final tally was 523 votes in favor, 46 against, and 49 votes abstaining. Now, for a little bit of background, if you were just coming to this conversation, the AI Act did not, as one might have guessed, start with the initiation of ChatGPT. In fact, they have been negotiating this law since 2021. And indeed, one of the big challenges for them, in terms of finalizing it, was how to deal with generative AI, given that it hadn't been part of the early negotiations. The central underlying premise of the EUI Act is to divide artificial intelligence into different categories based on risk. Louisa Jurovsky on Twitter did a good breakdown writing, "The AI Act follows a risk-based approach. Some AI systems," she points out, "are banned, including those that involve cognitive behavioral manipulation of people or specific vulnerable groups, social scoring, i.e. classifying people based on behavior, socioeconomic status, or personal characteristics, biometric identification and categorization, real-time and remote biometric identification systems such as facial recognition." You may notice, in other words, that what the European Union has classified as the riskiest potential applications of AI are basically these Skynet totalitarian surveillance types of applications. The next category down is a high-risk category, which is fairly broad. Some of the systems that fall into that category include critical infrastructure like transport that could put the life and health of citizens at risk, education or vocational training that may determine access to education and professional course of someone's life, for example, scoring of exams, safety components of products, the example given being AI application in robot-assisted surgery, employment management of workers and access to self-employment, think CV sorting software for recruitment, essential private and public services, e.g. credit scoring denying citizens opportunity to obtain a loan, law enforcement that may interfere with people's fundamental rights, for example, the evaluation of the reliability of evidence, migration, asylum and border control management, e.g. automated examination of visa applications, and administration of justice and democratic processes, like AI solutions to search for court rulings. So, of course, the common thread here is that these are all applications where the stakes of what happens or what is decided is extremely high for the person whose life is affected by that decision. It's not just physical harm or risk, but things that could impact someone's career, someone's livelihood, someone's legal treatment. And so what does it mean to be in the high-risk category? Well, it doesn't mean that things are banned like the highest risk category that we were just discussing. Instead, these high-risk systems have to be assessed before being put on the market and throughout their life cycle. What's more, there will be specific procedures and processes for people to file complaints about how these systems are being used. What about generative AI? This was a big sticking point and the subject of a lot of intense lobbying and negotiation. These types of tools will not be classified as high risk, but will have their own set of rules as per the AI Act. Specifically, they'll have to comply with certain transparency requirements in EU copyright law, such as things like disclosing that content was generated by AI, an obligation to design models to prevent them from generating illegal content, and publishing summaries of the copyrighted data that was used for training. The Wall Street Journal describes some additional requirements around generative AI. Quote, "Makers of the most powerful AI models deemed to have what the EU calls a systematic risk will be required to put those models through state-of-the-art safety evaluations and notify regulators of serious incidents that occur with their models. They will also have to implement mitigations for potential risks in cybersecurity protection. The provisions on general-purpose AI were added during the EU's legislative process. Industry groups in some European governments pushed back against the introduction of blanket rules for general-purpose AI, saying legislators should focus instead on risky uses of the technology rather than the models that underpin its use. France, home to Mistral AI, and Germany sought to water down some of the legislation's proposals. Mistral's chief executive Arthur Mensch said recently that the AI Act would, after some changes in final negotiations that lighten some obligations, be a manageable burden for his company, even if he thinks the law should have remained focused on how AI is used and not the underlying technology. So how is this being received? Well, obviously the lawmakers themselves are hailing it. EU Commission President Ursula von der Leyen writes, "I welcome the European Parliament vote on the AI Act, Europe's pioneering framework for innovative AI with clear guardrails. This will benefit Europe's fantastic pool of talent and set a blueprint for trustworthy AI throughout the world." Lawmaker Thierry Britton wrote, "Democracy 1, Lobby 0. I welcome the overwhelming support from European Parliament for our AI Act, the world's first comprehensive binding rules for trusted AI. Europe is now a global standard setter in AI. We are regulating as little as possible, but as much as needed." And indeed, that really seems to be the line that they've tried to hit, or at least that's the narrative they're going for. Romanian lawmaker Dragos Tudorek writes, "The AI Act has pushed the development of AI in a direction where humans are in control of the technology and where the technology will help us leverage new discoveries for economic growth, societal progress, and to unlock human potential." Not everyone agrees, however. Some of the loudest commentary, if you look at Twitter/X, are from those who feel that the law was too watered down and not strong enough. Daniel Leufert tweets, "EU officials boast about being global trendsetters in regulating AI, but with this law sets the lowest bar possible. The AI Act is full of concessions to industry lobbying, exemptions for law enforcement, and prohibitions full of loopholes." Amnesty International's tech account writes, "The AI Act is adopted today. EU policymakers are hailing the AI rulebook as a global paragon for AI regulation, but the legislation fails to take basic human rights principles on board. Countries outside of the EU should learn from the bloc's failure." Going on, Amnesty writes, "The AI Act offers only limited protections to impacted and marginalized people. It does not ban the reckless use and export of draconian AI technologies, while also failing to ensure equal protection to migrants, refugees, and asylum seekers. Similarly, it lacks proper accountability and transparency provisions, which will likely exacerbate human rights abuses." The notable thing here is that Amnesty's complaint is not actually about generative AI or big company power, it's more about the potential for abuse. Fanny Hidvegi, the Europe Advocacy Director at Access Now, writes, "The EU Act is a failure for human rights, a victory for industry and law enforcement." Access Now points out a similar set of issues as Amnesty, but also writes that the law, quote, "creates a glaring loophole via Article 6.3 for developers to exempt themselves from the obligations of high-risk systems." On the flip side are those, often represented from an American perspective, who think that this legislation is doomed to relegate to an innovation backwater. In other words, to incentivize European talent that might create companies and AI applications at home to instead seek less regulated places to build. Lawyer Preston Byrne writes, "The passage of the EU AI Act once again creates a rift between the USA and the EU, which the USA can exploit with legal protection for AI development. Europe regulates, America innovates, created the USA's multi-trillion-dollar internet boom, it can do so again." Of course, I think that we will have to wait and see to what extent that actually is the case. Will companies like Mistral give up on the European tech dream and simply return to the US and to Silicon Valley, places like it, or is that concern overblown? I am by no means an expert on this, and I have not gone super deep on this act, other than following along in the context of what we've been discussing here. Still, my general sense of legislation is that when people on both sides are pretty angry about it, that probably means it's hit the sort of uncomfortable compromise where most workable laws seek to hit. In other words, if one side or another is too happy about the rules, it may not represent the averaged out interests of lots of different groups. One of the only people I saw representing that perspective was the account from Growth to Value on Twitter who wrote, "The European Parliament has approved the AI Act. Everyone saying this is awful is either very biased or has not looked at it, and probably both. I think overall it's good. Social scoring, as is done in China, is absolutely forbidden. AI models can do no emotion recognition at school or work. It's forbidden to take pictures of people on social media for databases for facial recognition. Existing AIs like OpenAI's ChatGPT will have to be clear that a text or image is generated with AI. More attention to copyright infringements. 3 sensitivity categories from high risk to medium to low risk, plus forbidden AI. Overall, I think this is quite balanced." Now, in terms of where we go from here, the AI Act should officially become law in May or June, and then the provisions start coming into effect in stages. 6 months after the law officially comes into effect, countries will be required to ban those prohibited AI systems. A year later, the rules for general-purpose AI systems start to apply, and 2 years after that, the whole AI Act will then be enforceable. Notably, these rules apply not just to companies from Europe, but for anyone operating in Europe, and fines for non-compliance can be up to 7% of worldwide annual turnover. From where I'm sitting, I don't expect the debate about these rules to end anytime soon, but they exist and I think reflect the beginning of a regulatory catch-up period that is just starting right now. That is going to do it for today's AI Breakdown. Until next time, peace.